bring this meeting of the Board of Zoning Appeals to order. Roll call, please.
Mr. Lipscomb.
Here.
Mr. Farmer.
Here.
Mr. McKeever.
Here.
Mr. Stucker.
Here.
Mr. Stride.
Here. Everyone's here. Next order of business is to approve the minutes of our last meeting, which was November 12th.
Where did he go?
Three different issues there, and I didn't see anything that I objected to or didn't think was correct.
I'll make a motion. I'll second it.
Okay. All in favor of that motion that we accept the minutes, say yes.
Yes.
Okay. We need to have anyone who potentially would testify today to stand and take the oath of, with our law director, please.
Please stand and wave your right hand. Anybody
Rob,
prepared to
you
testify?
need to testify?
No,
Yes.
no, you come pre-certified by the state bar.
Yes, okay.
Do you solemnly swear or affirm that the testimony you provide today will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Please be seated.
Okay, thank you. Subject number one, Clyde Shuey of 1211 Marion Road would like to construct a new garage at the rear of his property. The zoning variance revolves around the garage being not revolves around that, the garage being 30 by 50, but he wants to build it 5 feet away from the south side lot line. The regulations for his particular area requires that be 10 feet from the property line. So he's asking for a variance to allow that to happen. Landon, pretty straightforward, is it?
Yeah, again, they are located in the R1 zoning district. In the R1 zoning district, we have a 10-foot side yard setback. Residential standards require that any accessory structure has to meet the side yard setback of the zoning district in which it's located, so it has to meet that 10-foot mark. They're asking for 5 feet, and the applicant can likely kind of explain why they're particularly requesting this. It has to do with the layout of their driveway and whatnot. You see there that we did receive one instance of feedback. That letter came from what I would perceive to be the most aggrieved adjoining property owner, which would be to the south there, and they stated no opposition to it. The only other question, which we just addressed in the office, would be where it would be placed in relation to the rear yard lot line, which requires a 5-foot setback, and they have assured me that they would certainly meet that standard.
Okay. So at least it would be 5 feet away from each property line?
Correct.
Okay. All right. There's nothing else particular, any comment that you folks?
If she would just like to speak on the why they're requesting it, she had a bit of an explanation for that.
Yeah. The way our property is, we kind of share it with the neighbors, which, they're on our property line. Their driveway, concrete's 5 foot on our property line, their flower bed, but we're all good friends. They wrote a letter saying it was okay. And, we have to put here's a driveway, the curb where we're gonna put it. The garage will be right here. Even if we don't, it'll throw our driveway off. And even though they have ours and we're letting them, we don't want to mess up the landscaping they've already done and spend all the money on that's on our property, which is fine. We just want a garage. We just want to put a garage there, and that's it. So
Okay.
we're just trying to make it even with the driveway.
Okay.
I'm Darla Dunworth. I live on the other side of her,
Okay.
and we would appreciate a garage. Because Clyde has quite a few cars that he can park in that garage, and tools and stuff that right now are out in the backyard. I think all the neighborhoods would appreciate it.
So you can move the stuff indoors and not have to look at it, is that what you're saying?
Right. I mean, they get upset about me. I have an old pump and an old well, and I have neighbors who have kindly asked me to remove the pump because it's not painted real pretty or anything. And it's in my backyard. Nobody sees my backyard.
Any questions of anyone?
I'd like to make,
Oh, you
Go
got
ahead.
it. You got it.
I'd like to make a motion to approve the variance for
I'll
the 5 foot
second that.
setback.
Okay. Absence any other comment, let's have roll call on that, please.
Mr. Stuckert.
Yes.
Mr. McKeever.
Yes.
Mr. Farmer.
Yes.
Mr. Stride.
Yes.
Okay, motion carried, you can proceed to go to Landon to get the necessary permits. And
Yeah, just make sure they stop over and get the proper permits, and if, I don't know if we got them registered or not, but if they're not a registered contractor, we'll have to get that taken care of too.
Yeah, thank you so much.
You're welcome. Sure.
Just push it. Okay, subject number 2. See, we didn't lose too many visitors. Yeah, I guess so. Kurt Fankhauser, owner of 510 North Sandusky Avenue, received a notice of violation relative to 2 temporary banners placed on the structure at his property, which we have a copy of the notice of violation. There are a number of different parts of the sign code that are mentioned here. 119109, 119107, 119106. I could go on and on, but the point of it is Mr. Fankhauser has filed an appeal to us concerning the interpretation and administration of the Bucyrus ordinance, codified ordinance relative to signs, and in particular, in this particular location. I guess we'd start this off by, Landon, would you help to try to explain
Sure.
the situation a little more?
So you guys all should have copies of the notice of violation, either included in your packet, or I think I included one on the table there prior to the meeting. Additionally, you should have, I printed out the sign ordinance and kind of highlighted the areas that I referenced in making this decision, this interpretation. So, to begin with, the sign, the decision was made that the sign is, by its definition, a temporary banner. Banner means it's non-rigid cloth, plastic canvas, typically related to a specific event or promotion. So being of that material, promoting this specific election, I feel it meets that definition of a banner. A temporary sign means a sign intended to be used or in fact used for a limited time period to promote or draw attention to a particular event. Again, this is a particular event, election, so I feel it meets that definition of temporary sign. While there's no set duration for the temporary signs, they do have to conform to all the regulations in the sign code. 1191.06A does allow for signs concerning candidates for elective office, elections, what have you, to be permitted or to be erected without a permit. However, in sticking with that, it still has to conform to the rest of the development standards for the signs. Banners less than 20 square feet in area are permitted, provided such signs are secured in each corner to prevent movement. So the question, in my view, of this interpretation is whether or not that sign is larger than 20 square feet. The approximate measurements of it are 27 feet by 8 feet, putting it somewhere in the neighborhood of 216 square feet, roughly 10 times the limit of that 20 square foot mark that we have for temporary banners. I know that's a lot of code talk and whatnot, so if you have any particular questions, I'd be happy to answer them.
Well, I guess the only question I would have right now is, how is this different from the one that was there 3 or 4 months before that?
I don't know that it is. However, this is a separate violation not related to that sign, and this meeting is an appeal to the violation that was issued for the current signs that are occupying the space.
So basically, there was no objection filed, the ones that were there before, just because it didn't happen.
It came up, it was discussed, and I think, I don't know if that was in the packet or not, it was discussed at a council meeting. Various council members indicated that they would like to take action on it and either clarify or change that ordinance as it pertained to those. I gave them the benefit of the doubt and said, okay, if you want to change it, you can change it and I'll enforce it that way. As that didn't happen, here we sit with the exact same ordinance and the signs are in violation.
Anyways,
Will I have an opportunity to speak before I leave? By the way, I don't know how this works.
Sure, go right ahead.
Okay, my name is Melissa Ackerson. I am a candidate, Republican candidate for Senate District 26. That is obviously me on those gorgeous, gorgeous signs, if you ask me. I do want to let you know that I am represented by Ratliff Law Offices. I am running in the most contentious race in Ohio's history. It's been dubbed as the ugliest primary in Ohio's history, and based on the fact that my attorneys believe that there is political motivation behind this, that my opponent is somehow involved in this, I do have public records requests of all of your information, including yours as well, to make sure that we have all incoming and outgoing telephone communications regarding this conversation, all emails regarding this types of conversation, and we have the media involved at this point, because this is very, very interesting that there were other signs similar in size, and yet I happen to be the first person that we're having this type of hearing over. That is the view of my attorney. I have representation out of Washington, D.C., who looks out for the interests of my donors and the hundreds of thousands of dollars that have been poured into my campaign, including the cost of the sign. And I also have an attorney who represents the campaign and has to lead, guide, and direct me based on the law, what's right, what's wrong, as well as the past practices that you folks have created in the past. So I do have public records requests that I do want to issue today to Mr. Ratliff, as well as all the members of the zoning board and several other elected officials, as we believe this is politically motivated.
All right, folks, I represent Kurt in this matter. Kurt came to my office. I don't represent Melissa. That's her issues are her issues. Kurt, as the owner of the property, has been, the last couple times, been renting out that building for the purposes of political campaigns. Part of the problem we have is that the interpretation of the statute has to be looked at in the light best, at its own writing. You can't interpret or add things to it that are not part of this. Basically, the initial argument probably goes to the definition in terms of what is a banner versus what is a wall sign. Now, the reason that is important is a banner normally is affixed at separate, usually 4 separate locations, either tied down or acted like some sort of tarp that is affixed to something, while a wall sign is said, by your definitions, it is a sign attached to a building face with exposed face. Wall signs include all sorts of things, but basically it implies it's affixed directly to the wall. Now, the problem number one is that our position is it's the wall sign because it is affixed, the entire sign is affixed to the building itself. And that, of course, would make it a wall sign versus a banner sign. The second issue is that in your definitions of your signage, you only talk about wall signs that are in fact permanent. And that's where you get your wall sign permanent. Must be something around, if I remember correctly, it says a wall sign must be to somewhere in the neighborhood of, and it doesn't talk about permanent or temporary wall signs, it only talks about banners. And so as wall signs must be not exceed 33% of the surface area of the building wall or architectural structure. Now, our position is, number one, that it is a wall sign that is affixed up there. It is a temporary sign which is not covered in your regulation. because clearly it is going down at some point, with March 17th being the election, it will be coming down soon thereafter, and that's the length of time we expect it to be up there. Further, we are thinking that it is clearly not covered as a permanent sign because it will be removed from the wall at that point. Therefore, we don't have any ordinance that specifies what a temporary wall sign should be. Now, our position is that it is not creating any type of hazard to the public. It is not in such a manner as to stop or impede traffic or road conditions. So our position pretty much is that as long as you haven't specified per your statute what a temporary wall sign should be, we meet the criteria. We don't have to ask for a permit because, again, your legislature has actually said that no permits are required for political signs. Now, we all agree, I think, by the looks of it, that it is a political sign. And we all agree that, in fact, past practices have allowed a sign to be there. And so the question, I guess, is that, is it a wall sign or is it a banner, is something that you guys have to work out. If it's a banner, then my client has to be told that, and he has to make a decision whether he will argue up to the Court of Appeals or not. If it's not a banner and it's a wall sign, then you have to decide whether or not it meets the criteria. And as I said, basically, I think we all agree it's a temporary sign. It's not going to stay up past the end of this election. And hopefully at that point, the legislative body will get around to deciding whether or not the sign ordinance needs to be changed to deal with this situation. Thank you.
I wanted to add something else, I'm sorry, before I forget. I think it's important to note also that my opponent, the individual who manages his campaign for Crawford County is Matt Kroll, and I believe that's your city prosecutor, who has also said his
No,
main.
he's the law director.
Is he the law?
He is not the law director.
City attorney?
City county prosecutor.
County prosecutor, okay.
So he's not.
Then we have this guy.
This is, and
Okay.
he's not taking a position in the election process.
What I'm concerned about, and coming directly from Matt, is, that he believes this is a violation of First Amendment speech, which is, a tremendous issue. He's concerned about the past practice that was set with the other previous signs that were up there of the two gentlemen who were running for office, one being a Republican, the other being a Democrat, to the point that he's actually kind of stepped out of this. And now my opponent apparently is being very helpful with looking for someone in the Tiffin area to come in and to handle this. I mean, to me, this is an egregious abuse of weaponizing institutions of government towards my supporters, towards my sign, and frankly, it's really not, it's not a fair way to let a primary play out.
Bill, please.
First of all, I'll start off with going on record saying that I will swear under oath that I have not been contacted by the city about this issue other than the email that I received of the packet of material from Mr. Travis. Now, I would say by Mr. Fankhauser's own admission that this would qualify as a banner, as he referenced a picture of a giant banner on a water tower that is affixed to the tower, directly on the plane of the tower, and this is the picture here. And he refers to it right at the heading that it is a banner. So I guess the determination here is this a banner or is it not a banner? Okay. The signs that are on Mr. Fankhauser's building appear to be made of the same material as this so-called banner wrapped around the water tower. Okay. So is it a banner or is it a sign?
Well, you basically understand that my position as my client's advocate here is going to tell you that based upon your description, that would be a wall sign. Because as far as I'm concerned, if the wall sign, if it's affixed to more than, it's not affixed just four corners and attached. A banner I consider is something that's either attached And I don't know, I'm not familiar with that sign that you're pointing at, but if it's affixed with rope or affixed at 4 separate locations, I would say that's a banner. If this is in fact, and as far as I've been informed, this banner, this wall sign that we're talking about, is affixed all across, all around the sign. It's not just affixed in 4 places where basically you have, you're viewing it as I view a banner as something that can move with the wind and just have, it's not something that's affixed to permanent, to place it so it doesn't move from the wall. This, however, is affixed to the wall. It cannot just be, it cannot be removed by somebody cutting off 4 grommets and it's done. It has to be actually unscrewed from the building itself. So that's where by my interpretation of the definitions that you guys have, that your legislature body, the city council has affixed this, we have to look at what that says. I understand that this is sort of like calling apples and oranges and trying to decide whether it's a Macintosh apple versus a red apple. But as far as I'm concerned, what we have to look at is based on the description of your definition and decide, is it a banner? And it says, it doesn't really talk about how it's affixed, but in the wall sign, it does talk about how it's affixed. So, again, that's my argument. That's why I believe that this is a wall sign, not a banner. I personally, without going out and looking at how that's affixed, because I'm not climbed up that water tower to look, and if I did, my wife would probably yell and scream at me if I did that. I would have to say that it is probably a wall sign.
Well, I just want to say that this picture was sent to me by Mr. Fankhauser himself, and that he has stated on the picture, I'm assuming that he applied the print to the picture, that it is a banner.
Okay.
That's his saying that it is a banner.
Well, again, I would go to how it's affixed, and I can't tell you that.
Mr. Chairman,
Yes.
sorry, Andy.
No.
To address the content of the sign, there's no issue with the content of the sign. If the sign met the 20 square foot requirement, it could be there without a permit and no issue. If Mr. Fankhauser would have liked to pursue a variance to our sign code, which there is a provision that allows you to pursue any variance to our sign code that you wish, he could have brought that before this very board and requested to have the sign of his choosing, and whether or not they approve it or not, that's up to them. However, that avenue was not pursued. It is not an issue with the content of the sign related to any specific candidate. It is simply whether or not that sign is bigger than 20 square feet. Now, if we want to make the argument that it is a wall sign, and whether or not this would require an additional notice of violation, I don't know. That's probably a better question for Rob. But if you want to call it a permanent wall sign, I would say that it meets the definition of an off-premises sign, which means any sign that identifies or provides information related to a good, service, event not located on the property where the sign is located. I feel that would meet this definition. An off-premises sign is required to get approval from this board, the Board of Zoning Appeals, and in the provision allowed for those, you're not allowed more than 1 sign, and the sign face, again, cannot exceed that 20 square feet mark. So even if it was to be considered a permanent wall sign, in my opinion, it is still in violation of this without pursuing a variance, like I mentioned.
Can I ask a question here?
Absolutely.
Based upon that, I agree the permanent sign makes it a big difference here, but are we all agreeing that this is not a permanent sign? See, the issue here, as far as I'm concerned, is yes, you have a specific ordinance that deals with permanent signs. We are saying that this is a wall sign because it is it's affixed to the wall. But we also are saying that it's a temporary sign where you do not have any legislative regulation dealing with a wall sign that's temporary. So,
Yeah, I would say that
okay,
the violation notice, claiming
again,
it's a temporary banner sign, that's what we're here to discuss.
well, as I said, this is, I consider it a temporary
Typically,
wall
in
sign.
other instances in the code, if there is not something that is specifically permitted, it is considered to be prohibited. So if
No.
there is no
You
provision
can't
to
do
allow
that.
for
You
it.
have to prohibit it or you have to state.
I'm not doing anything, I'm simply reading the code.
Okay.
Who initiated this complaint?
Initially, when Mr. Boer's signs were up, Kurt was actually the one who brought it to my attention. He questioned whether or not it was,
No, I mean with mine, like this entire,
I honestly don't know. Kurt, it was an ongoing issue with posting signs on this building, and
well, someone had to initiate this, though. Someone had to have done that. Someone had to have made the initial complaint. And we'll find out through extensive discovery, of course, and when we start doing subpoenas and going through the court processes, but certainly you must know who initiated this complaint.
if I
Well, if
must,
it's a
I
violation of
don't.
code, it doesn't require a complaint, it's a violation, whether anybody complains or whether they don't.
Mr. Chairman,
Yes.
I just want to bring up, we did grant variance to United Bank, who exceeded 20 square feet for a temporary banner. We're willing to work with people if they follow the procedure of asking for variances. Am I correct?
And
I'm just bringing that up.
I could be incorrect with that, but I've been on this board for maybe 6 years.
A lot longer than me.
And I don't think, that's the only time I think I ever remember us ever even giving a variance on the size. Whatever the size required is what you have to live within those requirements. So we've been very strict in maybe some areas of the sign regulations, but not on size. So I think.
But we
that's
did
right,
grant
yeah.
that for them.
Right.
And it was only temporary too.
That's correct.
That's
No, but while I've got the floor here, one other thing I'd like to mention, and we were talking about size of signs. This 119107, it says general requirements for temporary signs. A, right off the bat says banners less than 20 square feet are less than 20 square feet are permitted in this area, provided they're secured at the corner and so on and so forth. So that we kind of run into a lot of problems because, here's signs. We've got 16 different types of signs and variations on these regulations for each one of those 16 different types. So we can run into some problems because of all these different twists and turns. Bill, you want to make a comment?
Yes, I just wanted to say that as far as the code goes, I don't think the code should prevent political signs, candidate signs, or whatever signs, as long as those signs are not interfering with public safety and so forth. In fact, I think that as far as these signs go, they definitely are not a violation of the purpose of the code itself, just in violation of a specific aspect of the code. So I just wanted to go on record as saying that I am not against these signs at all. I just wanted to
I think
state
that
that I
it is.
think that they are, and I believe even by Mr. Pankowski's own admission, that it is like the banner that he calls it on the water tower, that type of a sign, and I think it is a banner.
Personally, I would agree with Bill. I mean, although I do think there should be some size limitations to it, if the council would say that this is what they want, fine. Personally, it does not offend me in any way at all. However, my job as the zoning administrator is to interpret these codes, and the violation notice that I issued is based on my interpretation of these codes professionally. So yeah, I would agree with Bill personally, but unfortunately, my personal opinion does not affect the decisions I make as the zoning administrator.
Well, here's my spin. I'm not so concerned about how it's attached to the wall or personalities or politics. I'm concerned that everybody gets fair and equal treatment. And I think, I think when you have them up there for 3 months and then you put the same thing, and all of a sudden it's a violation, just something don't smell good to me. but that's my opinion.
And I don't, honestly, I don't want, I've got 2 lawsuits going on right now just to be able to run for office. I campaign 7 days a week. My kids get drug around with me. I'm walking away from my small business, putting a heck of a lot on my husband's shoulders to do this. I don't want to start a 3rd lawsuit. I don't want to go through more discovery. I don't want to be back in the media again. But I will tell you that the view that I have personally is, you had 2 other individuals, both Democrat and Republican males, who didn't have to go through this, and now that I'm running for office, I've got $100,000 sitting in the bank, I'm the front-running candidate, I'm being hit with opposition in every county I go to, where suddenly people start enforcing things that they didn't prior. So even if I wanted to ignore this, I have attorneys that represent my interests, I have donors that expect me to defend myself, and I have a guy out of Washington who manages this campaign who's saying, you're gonna fight this tooth and nail, you're not gonna remove the signs, we will work through attorneys, we will go through extensive discovery, and you will prevail.
I would take exception to the fact that I would issue any violation based on any kind of sexist ideology.
I'm
or
saying how the outside
political
world.
ideology or anything
Sure.
along those lines. I would take exception to that
But
statement.
you can imagine what this looks like. I mean,
And, through whatever discovery process we go through, you're not gonna find anything that I was pressured to do this by your political opponent or anybody else. I am simply doing my job as the
No,
zoning
we're
administrator.
not suggesting that.
Well, I think.
Well, I mean,
I do not believe that.
I felt I needed to defend myself.
I don't think that you're doing, I'm just letting you know that just as we all have eyes and ears all over the place, I can assure you, my opponent is very much aware of and involved with what's happening right now and is very much a hand in what's going on. That may not have impacted your decision or your thoughts or your personal feelings, but I mean, I'm trying to run a primary in a free and fair republic, and a lot of rules that don't apply to other people are suddenly applying to me. And I've got to fight back because the treatment is disparate, and I think we've got to use all avenues of the media, of legal avenues, and we've got to expose what's going on.
Well, unfortunately, I think if we would, here's my spin, if we were to have a sign even similar to the size that our regulations require here, it doesn't get anybody's attention, whereas one that's so large, I don't care who it is, they'd be back here at this particular board having to justify, try some type of relief on that, because that's,
Sure.
I had no idea that there was anything I've never heard anything about any kind of problems that you're, good grief lawsuits and who knows what all,
I use the
Constitutional
same measurements, and I try to keep all my money locally in the district because I don't like to hire outside for campaigns, with the exception of a strategist in Washington DC. But I hired the same company who did the sign for the gentleman previously and used the exact same measurements for that sign.
Gentlemen, I'm sure if Mr. Fankhauser would be probably willing to modify his objection to a request for a variance, it would make it easier for us to maintain the current signage and where it is, giving council an opportunity to look at this and realize that I believe there's some issues here. I don't really want to put the city in the middle of a fur fight if we can avoid it. And I think, but as I said, Mr. Fankhauser would like, obviously had a contract to have these signs up, put the signs up on his property and felt that he had a legitimate reason to do so. So we would be willing to do a variance, modify this to a variance request, if that would make it easier for us to come up to a compromise to keep the signage up without affecting the current statute. But I think that the advice to me would be that you should notify council that they may need to look at the signage documents to deal with this problem before the next general election.
yes, Bill.
Yes, this issue, it is not against you, ma'am, the candidate. This issue has been going on for some time about the signs, locations, and size, and so forth. I do believe that if it is possible to change this to a variance request, that would probably be the best approach here. I don't know, Rob, is that possible to do that without going through a whole new process again?
Well, procedurally, you've got a violation that's already occurred. So what's
Yes.
before the board at this point in time is whether or not you're going to enforce the application. The time for a variance is prior to doing it, and would be a separate proceeding. But, yeah, I mean, you've got the offense in front of you. So your decision at this point is limited to just the grounds of the appeal of it, I would say procedurally.
Or whether they want to enforce the offense or not at this point.
Whether they want to uphold
Right.
Landon's notice of violation. Now, the procedure after that is, it's kind of been Landon's hands at that point as well. He can refer the matter for prosecution or, take no steps. But that's, right now, what's before you is simply the appeal as to whether or not Landon's violation, notice of violation is appropriate under the ordinance.
And if I can just wrap up, I just wanted to say, I think what was concerning for my attorney, for Rocky Ratliff and J.C. Ratliff, you know Rocky.
I know Rocky.
Right. What was concerning for him, he said that the fact that Matt Kroll, who is the city prosecutor, said, I've got to recuse myself and pull out of this. I think it's a violation of her First Amendment rights in political speech. And we're going to work with Bill Reineke to find someone to prosecute this out of Tiffin. I thought, this isn't the way that things are supposed to work. I wanted to be here today, to meet you folks in person, to let you know what's happening behind the scenes. And I think that this situation is just being used as it's a political stunt. It really is.
And just as an aside, Matt's office wouldn't prosecute this, my office would. And because of Kurt's incoming position with the city, we would probably refer the matter out, but no attorneys have been contacted. That would get prosecuted. It wouldn't have, Matt's office wouldn't prosecute it.
Well, I have a question, Rob. I don't know what the right protocol would be. Would it be possible to table this subject to getting a request for a variance?
The violation's already occurred.
Yeah.
So, I mean, you can apply for a variance, but it doesn't cure the problems, the violations up to this point. So it'd be a separate action.
Let me ask you this, Rob. If they do uphold it, or if they say I'm wrong and do not uphold it, you said it's up to my discretion as to what that next step was. If I was willing to entertain him submitting a variance application in lieu of turning it over to you for prosecution, is that a step that I can take?
Yeah, you have that discretion.
I would be willing to entertain that. Again, this is nothing specifically aimed at anybody, I'm just trying
And we
to
would
dictate
be
what's
willing
in
to
this
get you a
book.
variance within a very short time.
So if you guys want to hear this, and then at that case, like any other variance, anything that exists outside these black and white words that I'm paid to enforce is up to your guys' discretion. If you feel it's appropriate for a sign of this size to be displayed there, whether we're applying for a variance from the temporary banner, or whether we're applying for a variance from the off-premise sign, whatever the nomenclature we choose to use is, then that's up to you at that point, and obviously your decision would hold. And I'd be fine with entertaining that. In fact, I would have preferred he submit for a variance when this whole thing started, and we could have avoided all of this, but that's not how it shook out, so.
I think it appears to me as though
Sorry,
it's
in
all.
additional to that, I don't think it's a bad idea that we request council take a look at this.
Yeah,
Because if
yeah.
we're gonna get into debate whether or not this sign code is written well, I'm not gonna tell you what side I'm on, but I'll enforce it however it's written, and this is the way it's written
At
currently.
this point, it's written so that there's potential for an argument, a no-win situation. I mean, it is.
Somewhat
And-
ambiguous, yes.
Yeah, it is, and so, as we've all alluded to, there's some bad past precedent of certain things going on that by allowing them to continue, we actually approved them, more or less, or whatever. And that's partly because the rules of the game are just, they're not, you know, you could interpret any of these signs in the city to be in 3 or 4 different categories. And so then in this category, there's one rule, this category, there's another rule. And so this time we hurt this guy, and the next time we don't hurt him, and we need for your benefit and for our benefit to have a lot of clarification. Because I think in all the time I've been here, the majority of the discrepancies, discussions, differences of opinion or whatever, contentious have been signs. I mean, bar none. When you see a sign come, oh man.
I have
here we go
already,
again, you know.
recently I addressed council, Mark, Kevin can speak to this, for discrepancies in the downtown business district as it related to signs. So, you know, as I've been working my way through it, I'm new to this position, I'm still trying to work my way through this code, but as I find those discrepancies, I'm trying to make it a point of emphasis to get them addressed.
And we did modify those.
And we did. So, you know, yeah, it's not like I'm
I understand.
trying to go out of bounds here or anything.
So if we enforce the complaint violation, then you have the authority to say we can get a variance and problem solved.
I would defer to Rob on that.
Yeah, I mean, procedurally, if you uphold his complaint, it throws it back to him, and just like a state trooper deciding who he's gonna pull over for going 80, he has the authority to make those investigatory and police-related activities. I mean, in that role, he sits essentially as a police officer, and what I point out to the board and to everybody is, you know, look, I drive between here and Cleveland a lot, and there's a lot of times I might not be going exactly 70. You don't get pulled over every time, you know, but when you do, you do. And so with most criminal ordinances, and Mr. Motter, I know does a lot of criminal work in court, as do I. With most criminal ordinances, that is the way it works. You don't always get charged every time, but you know, when you do, you do. And that's why we have things like prosecutorial and investigatorial discretion, and those things are built into the law for those kinds of purposes. So yeah, if you uphold it, it kicks it back to him, and he can work out whatever kind of arrangement, agreement he sees fit on any particular matter.
Well, that makes sense to me, and I'm sure Atlanta will do the right thing, so.
Well, I sort of don't want my client to be suddenly thrust with $1,000 or the $100 a day, or it's
It's $500
$500 a day.
I thought it was between 50 and 500.
50 and 100.
Yeah.
50 and 500 for each day.
That's what it is.
So, I mean, that's part of what, I mean, if it goes the other way, I don't know, I mean, what I would like to do is if we could all agree that this goes the route of the variance, I'll be glad to get him the paperwork tomorrow for the variance, and that will be the way we go, and
Those fines don't kick in until I forward it to you for prosecution, is that correct?
Those are imposed by the court.
yeah.
So it wouldn't get there until I forward it to you for prosecution.
All right.
Yeah.
Which, if we agree to go this route, I'm not going to do. I'm going to allow for you to pursue the variance.
All right.
Yeah. You can short circuit me or whoever the prosecutor ultimately.
Always short circuit you. I mean, it's kind of
Best
fun.
thing to do.
Will we know though today what your decision is? So that I can contact Rocky afterwards and say, hey, here's what's gonna happen, this is what the next step is.
My decision as it relates to,
The variance, approving the variance?
it's not my decision to
These
approve
guys'
the variance.
decision, and
It's
they
the
would have to
variance.
decide
decision to approve.
in January, whatever, 15th or whatever day it is,
Okay.
that they would be making the decision on the hearing.
Is it 20 days? Do you have to do it within 20 days of
20
his
days.
application?
Well, for a typical variance, there's no set time period. We do have to allow for the notification of adjoining property owners with the letters, post the signs for 14 days prior to the hearing. We do have to follow all the notification guidelines. With The holidays, my assumption would be, will probably be dragged somewhere into the middle of
Late January.
January, yeah, by the time we could get it.
If we employment, whatever that is.
But we gotta do the 14-day notice period.
But it's gonna be pretty much a limbo until you move forward a drought, which.
Yeah, which I'm, if
but
we're going
but
this
if you
route,
get-
I'm
but
agreeing
if you
I'm
get-
not going to do.
But if you get the variance, then that nullifies
Mhm.
the rest of it.
And
Makes sense to me.
Landon, I just want to make sure you are going on the record that you've not had any communication as it relates to my race or with Bill Reineke or with the opposition related to this incident.
I don't even know who Bill Reineke is.
That's great. And neither should any of you. Vote Atkinson on March 17th.
There. Always nice to hear that from a politician. You don't know the opponent's
Right.
name.
Well,
Right.
matter of fact, I was gonna ask the same question you did. Who is, I didn't know either.
Okay, great.
I honestly could not have
Car
told you
dealership
anything
or
prior.
It doesn't matter.
Prior to the hearing.
It doesn't matter.
And I am a registered Republican. Not that that makes any difference. Okay,
Well,
we need to make some motion.
essentially, in this
relative
case,
to
the motion would be that it's upheld.
Right.
And then I have agreed not to
Okay.
forward it for prosecution until a variance has been applied for.
Okay.
Do we need to set a time limit on the time frame to receive a variance?
We will have a variance. The only problem is gonna be to get it before Christmas.
Well, yeah, I
So
mean,
we'll get it
I'm
before
not
Christmas.
talking tomorrow, a month, whatever.
That, again, that falls into your
Bailiwick.
jurisdictional discretion, as it were. So, yeah.
You the boss.
Yeah. You would at some point in time either have to issue a second notice of violation or refer to prosecution. Until you do either one of those things,
I'm all for
nothing really
fair. I
happens.
just want fair. That's all.
Okay, I'd like to have a motion that we proceed in that direction, that we, I think you better state it.
Well, I am going to make a motion that we uphold the not notice of violation, from violation, until such time as Landon can make other arrangements.
I'll second it. Okay. And that, let's have a roll call on that motion, please.
Mr. Farmer?
Yes.
Mr. Stride?
Yes.
Mr. McKeever? Yes. Mr. Stucker?
Yes.
Motion for denying the variance is carried with the stipulation that Landon will proceed with the variance.
And the request comes.
Rest of the variance, yeah, that request. Are you, everybody in agreement of what's?
I understand what you've agreed to
Okay.
here,
Yeah.
yes.
Okay, all right. Have anything else future? down
No
the road?
additional information for this board, but for yourselves as members of another board. We have received an application from the Board of Building Standards and Appeals as it relates to a,
Certain house on East Mansfield?
no, it is a property on High Street, and it was a nuisance declared or something along those lines. I only bring it up because Greg's gonna be out of the office here on vacation, so I'll probably be working with you guys to get that scheduled. If you wanna check your calendars, we do have to have that scheduled within 20 days.
Talk about these guys, I'm available.
Of it being
These
filed.
Florida-bound guys.
So I'll get with you guys on that, or maybe Greg can before he leaves tomorrow, reach out. But either way, with Greg, in Greg's absence, either I will act as secretary or we'll enlist Alyssa out of the law director's office or whatever, but, so just keep that in mind, check your calendars, and we'll touch base with you.